I'd just like to reserve 2 minutes, please.
How much?
2.
2. Very good.
Good morning. My name is Connie Reguli. I'm here this morning pro se on my petition for a public records request against Williamson County. This case should have been a rather mundane public records case that follows a pretty clear statutory scheme and is supported by the public's right to examine government records, which has been recognized in Tennessee for more than a century. However, the case turned sideways when the judge took on the role of a moving party on his sua sponte Rule 11 motion. The brief includes a great detail about the context of the court proceeding, including several comments made by the judge and him ordering the testimony of confidential communications with other government officials. However, this is a public records case. It was filed in accordance with the statutory provisions of Title 10, Part 7, Sections 501 et seq., which shifts the burden of proof to the government to show cause why the record should not be produced. The Williamson County attorneys filed some legal arguments with their response, claiming work product, common defense, attorney-client privilege, but ultimately they just asked the trial court to defer to a district court ruling which was considering a motion for a protective order. The case took a surprising turn when the trial court shifted his position from just being the tribunal to being the moving party on his sua sponte Rule 11 motion. In the March 29th hearing, the trial court discussed knowledge that he obtained as a trial court judge over the case of State v. Juan Cruz, a campaign mailer he received from myself, the appellant, and he solicited unsworn testimony from the county attorney, Ms. Carson, asking her about the county's insurance reservation of rights coverage of Juan Cruz. The trial court claimed that the appellant made a statement in the petition that was false regarding a Sixth Circuit opinion, and it was a, quote, fundamental predicate to the petition, and therefore subjected it to Rule 11 sanctions. The appellant, myself, responded to the court, arguing that the county had not produced any reservation of rights letter. The county never responded that they did not have the records requested. The county never produced any evidence that it contained common defense or attorney-client privilege, and Juan Cruz lacked standing to oppose the records. By the end of the first hearing on March the 29th, the county attorney admitted that the county would comply with the federal court decision. On April 11th, I filed a Rule 10b motion for recusal of Judge Woodruff. The motion outlined that he had recused himself sua sponte on appellant's criminal matter without explanation of his conflict. He had allowed cross-examination of myself regarding the political campaign. He had compelled disclosure of unrelated private conversations, and he used the proceeding to insert his knowledge on another unrelated case. On all appearances, the trial court had become personally aggrieved and had taken on the role of adjudicator and advocate on his own motion, and there was a perception of bias. The trial court denied the motion and entered an order on April the 20th. However, the order was not properly served. This was one of 5 orders that did not comply with the Tennessee Rules of Civil Procedure 5.022. The orders from March 29th, April 4th, April 20th, April 25th, and May 17th all failed to meet the electronic service requirements. Having not received the April 20th letter, I filed a supplement when even more information was discovered. Judge Woodruff's son had made public comments about the pending proceeding. Judge Woodruff had personally appeared in the appellant's criminal matter from which he had recused himself, and it was also discovered later that Judge Woodruff had made campaign contributions to the appellant's political rival and did not disclose it on the record. On April the 25th, Judge Woodruff denied the supplement, claiming it was not properly filed, and justified showing up with his staff to the criminal trial. This order was also not properly served. At the April 26th hearing, the appellant provided the court a letter from the county attorney acknowledging that the protective order from the district court was denied and they were in a position to start preparing the records. After this, the trial court took the testimony on legal fees from the county, and then the remainder of the hearing was dominated by the trial court advocating and ruling on his Rule 11 motion. The trial court claimed that the appellant had failed to make a reasonable inquiry as to whether or not the records existed, and therefore the public records had no evidentiary support. The appellant argued that there was no requirement to research whether records exist, and the county never said the records do not exist. The trial court claimed that the appellant made a factually incorrect statement on the Sixth Circuit opinion and therefore made a materially false allegation that was a fundamental predicate of the public records request. The appellant argued that the only factual...
Ms. Reguli, on that last point, where is the error there in terms of your description of the Sixth Circuit opinion? The trial court judge here thought that was a misrepresentation of the opinion. A trial court judge was concerned about the nature of an exhibit that was provided that the trial judge looked at as distorting what the Sixth Circuit had actually held in that case. Where is the judge wrong in that analysis, if the judge is wrong in that analysis?
Well, I think that the judge was incorrect in the analysis, number one. It was a reported opinion, and it actually was a precedential reported opinion about toxic conditions of confinement for juveniles.
But was there a holding by the Sixth Circuit that what Mr. Cruz had done was a violation of the Eighth Amendment?
Okay, so it was not Mr. Cruz.
Not Mr. Cruz,
okay.
Okay.
It was on Williamson County.
Okay.
That the conditions of confinement, now it was on summary judgment, and it said if all the facts are taken as true, but it was precedental as to a finding that juveniles also have a constitutional right protected from toxic conditions of confinement. However, the bottom line is it is not a fundamental predicate of a public records case. Judge Woodruff was very aware of that J.H. v. Williamson County case as he had presided over the State v. Juan Cruz case and under part of the government tort liability case.
Does it have to be a fundamental predicate? I mean, is there a misrepresentation that's occurring in the briefing here? And if you're asserting that the holding is one thing and preparing an exhibit that represents that as the holding of the case, and it's not actually the holding of the case, then does it matter whether it's a fundamental predicate or not?
So to be a materially false allegation, I don't think it was a false allegation, but to be a materially false allegation, yes, it would have to have something that affected the case, because that's what he said. He said it was a fundamental predicate, which means as a fundamental predicate means as an essential element of the case, which it was not. It was a summary statement about the seeking of those records. So the Judge Woodruff sanctioned under Rule 11, he ordered a penalty of $5,000. He stated that the appellant could not file anything in the 21st Judicial District without a Rule 11 review. He dismissed the entire case, denying all the public records, and he ordered discretionary costs. And then the appellant filed a motion to alter or amend, and the trial court denied that without a hearing and chastened the appellant not to file an appeal. On the issues, I want to first talk about issue 4, which I address as the excessive fine. I addressed the $50 fine limitation of the Tennessee Constitution, Article 6, Section 14 in detail, but I can sum it up with one quote from the City of Chattanooga v. Davis. Quote, when the predominant purposes served by the penalty are to provide general and specific deterrence and ensure overall future compliance with the law, then the monetary penalty should be deemed to serve punitive purposes for analysis under Article 6, Section 14. The Davis case describes when a judge can order monetary penalties as a remedial measure and avoid the Section 14 limitations, such as compensation for loss, reimbursement for expenses, to disgorge ill-gotten gains, restitution, and prospective coercion. However, the opportunity to rely on prospective coercion is very limited. A suspended fine, a per diem for noncompliance, or a purgeable fine, and none of those apply. Therefore, the $5,000 fine, which was paid, needs to be vacated as a matter of law and as a violation of the Tennessee Constitution.
Ms. Reguli, would you agree that this is a novel determination that's before this court in terms of how Rule 11 interacts with the $50 fine clause? And there's not authority that sort of lays out how these two fit together, or is there authority that educates this court on how Rule 11 intersects with the $50 fine clause?
I don't think you need an intersection between the two. The Tennessee Constitution is very clear as to what a judge can do without a jury. And it clearly, he marked it as a penalty. He called it a penalty. It falls within the penalty description of City of Chattanooga v. Davis. I think there doesn't need to be a case that shows that intersection. Okay. All right, on the Rule 11, also asked that that be reversed. And I would argue that the Rule 11 was based on faulty legal conclusions. Because number one, the court did say that the quote-unquote false statement was a fundamental predicate, and that's what he relied upon. It was, and as I already argued, fundamental predicate means it's an element of the cause of action, and clearly it was not an element of the cause of action. The court concluded that the petition had no evidentiary support because the county finally said at the hearing they didn't pay for the criminal defense. However, the court discounted that the request asked for all attorneys paid, experts, expenses, etc., and was not limited to criminal representation. And second, the county had never responded, records do not exist, which would be their appropriate response in a public records case if there are no responsive records. And finally, the court says that the records were requested for a bad purpose. However, there's no case law that said records should be denied because the petitioner seeks to disclose records to the public or to criticize government officials. It's a faulty conclusion of law to find that the use of public records amounted to a Rule 11 violation.
Mr. Reguli, would you agree that in terms of the harassment and delay rationale that was offered by the trial court in this case, was your only response to that to essentially address that it's in another proceeding, that it's in a different proceeding and therefore it's not applicable? Were there any other arguments you raised in opposition to the harassment delay theory, or was it just separate proceeding, therefore it doesn't apply?
Well, it's separate proceeding primarily. However, the use of public records, it is not a reason for denying them. Whether you want to harass a public official, whether you want to expose it and say that they're using funds for something that are inappropriate, it does not apply to a public. The use of those records should not prohibit the release of those. All right. Also on the issue of the denial of the recusal, the judge, it shows in this case that the judge had taken this on personally in some of his responses and the orders, justifying coming to the appellant's criminal trial with his staff, saying it was public interest, admitting or stating that he had never shared non-public information with his son, but not denying having out-of-court discussions, and then multiple threats of contempt and chastening the appellant not to appeal. Then there were issues, and I see I'm out of my primary time. I think I can cover the rest in rebuttal.
Thank you, Ms. Reguli. We'll hear from the appellee. Good morning.
May it please the court, I'm Lisa Carson of the Williamson County Bar, and I represent Mayor Rogers Anderson in this appeal. It's important at the outset to focus on the fact, I think, that this appeal is not about Ms. Reguli's or anyone else's ability to access public records. It is not about the merits of the case at all. The merits of the public records request were decided by the court before the Rule 11 hearing was set sua sponte by the court, and the dismissal of the case with prejudice did not relate to the merits of the case. It related to a sanction for Ms. Reguli's behavior in the case. Now, she has consistently in her briefing and in her pleadings attempted to conflate the bringing of this action with the making of the records request. And she's done the same thing in oral argument by saying, whether I want to use public records for harassment or not doesn't matter, I have a right to request them. That may or may not be true with regard to the records request itself. I would suggest there are some limitations on that, but that's not what we're here about today. We're here about the improper purpose for filing the lawsuit, the public records lawsuit, and the misrepresentations of fact made in that lawsuit that justify Rule 11 sanctions, not about whether there was an improper purpose for requesting the records in the first place. Now, the Rule 11 decisions of Judge Woodruff, of course, are subject to an abuse of discretion standard. And the case law is very clear that because Rule 11 violations in particular require fact-intensive determinations about the reasonableness of an attorney's conduct based on a variety of factors, this court should not disturb the trial court's discretion unless it finds that the lower court decision had no basis in law or fact.
Counsel, how is this statement let's assume for purpose of argument that it is a misrepresentation regarding the Sixth Circuit decision. How is it material? What's the materiality of it?
Well, first of all, my suggestion to the court would be it doesn't matter whether the statement is material or not to the case before the court. Rule 11 refers to any factual misrepresentation in a pleading. And in fact, the fact that it probably is not particularly material to the public records request that was before the court supports the argument, the other basis for the Rule 11 sanctions, which was that it was included there for an improper purpose. The record, particularly my examination of Ms. Reguli at the public records hearing, is replete with examples of her taking snippets of things filed in various courts and then putting them out in various forums before the Williamson County Commission, in campaign documents, in social media posts, and taking those out of context to serve various purposes, primarily harassment of county officials, I would suggest. And so her decision to take that Sixth Circuit case out of context, to attach a section of a slip opinion when that case had been a reported case for 2 years at that point, and then to try to create the impression that there had been a factual finding of a violation of this young man's constitutional rights, when in fact the county had won summary judgment on these issues, was not only for an improper purpose, but was false, and whether it was material to the public records litigation or not, it violated Rule 11 because it was a factual misrepresentation before a court. And for a party or a legal counsel, and when this was initially filed, Ms. Reguli was both. She was a licensed attorney at that time, and she was representing herself pro se. To suggest that I can put as many lies in a pleading as I want as long as I can convince the court later that I put it in there for no reason because it has nothing to do with the case, I would suggest would turn the integrity of the court system on its head.
In terms of the $50 fine provision of the Tennessee Constitution, City of Chattanooga, the Davis case, draws a distinction between remedial versus punitive. How can we look at the $5,000 penalty, which was described as a penalty by the trial court judge in this case, as anything other than punitive rather than remedial?
I think of the three sanctions that were imposed by Judge Woodruff, that is the trickiest one, Your Honor. I would agree with that. Primarily because, much to my surprise, there was no case law out there addressing this in the context of Rule 11, and I would have thought there would have been by now because, as the court knows, Rule 11 refers to an option of paying a quote-unquote penalty into the court. So it's an option expressly allowed by the rule. My suggestion would be that it is a remedial rule because, unlike the City of Chattanooga case, which dealt with violations of municipal ordinances, Rule 11 deals specifically with the province of a trial court or any court to address the conduct of litigants and attorneys before that court. So I would suggest that it's remedial in the sense that any sanction imposed under Rule 11 is directed toward that preservation of the court's
Hasn't the judge
integrity.
in this case indicated that this is aimed at future deterrence, that this is a penalty aimed at future deterrence, that the trial judge says, I put in a penalty last time and that wasn't enough to stop it, so I need to put in more significant penalties because I've got to stop this in the future because I'm concerned about how this attorney is comporting herself in my courtroom. And future deterrence seems, and Ms. Regula read the language from Davis, boy, does that seem pretty spot on in terms of what the Tennessee Supreme Court has told us is punitive. And we're starting with the default already of penalty suggests punitive, but even beyond that, the trial judge in this case seems to have specified that the purpose was future deterrence to avoid, and this isn't something that's held sort of, it's not sort of being held over her in terms of it could go away. It's a penalty being imposed. It seems like punishment.
And I hear you, Your Honor, and I agree that this is again, the stickiest. I think the trial court's discretion clearly allowed the dismissal of the case with prejudice under Rule 11 and under Rule 41. I think it clearly allowed kind of the pre-screening for Rule 11 purposes. I would note that the prior imposition of fees with Ms. Reguli was not a penalty, but rather was a payment of another party's attorney's fees. So this would be the first time that there was a quote-unquote penalty paid into the court. And I would agree that certainly one purpose of Judge Woodruff's imposition of that fine was an attempt at future deterrence of specific behavior that had repeated itself multiple times with this particular litigant. And it's a narrow situation where these penalties or where these remedies were imposed. It's a situation not in which you have a litigant who's being subjected to sanctions because of the bad behavior of his or her attorney. And it's not a situation where you have an attorney who's caught between sometimes that tension of zealously representing a client and stepping a little bit over that Rule 11 line. Here we have a legally trained pro se litigant who knew exactly what she was doing and who was using legal strategies for other purposes that were improper purposes.
Counsel, you've asked us to draw a distinction between the underlying public records request and the lawsuit. Can you explain that a little further? Why are we pulling those two things apart here? And Ms. Reguli is, in her argument, pulling them together. Why should we separate them? I mean, if, for example, the harassment or bad purpose analysis, and we seem to be going in a pretty bad direction with regard to public records requests if we're going to deny them because somebody may use them for a bad purpose, with that being very highly subjective. How are these two things separate rather than together? Can you walk us through that?
Sure. Well, the records request, one can make a public records request without making any representation in fact at all. One can fill out the county public records form, or frankly, if one wants to inspect records, can simply walk in and ask, subject to redaction of those records appropriately, of course. No reason at all. In the public records suit, however, Ms. Reguli could have filed a petition that simply said, I want these public records if they exist. But she didn't do that. She chose to file a suit when she knew there was a pending motion in another court. Keep in mind, the county had not said, we refuse to give you these records because you think you're going to use them to harass the county. The county had said, there's a pending motion for protective order that has been filed by a former county employee about these records. If we produce these records and then the federal court says you shouldn't have, then the horse is already out of the barn. And it's the improper purpose in plowing ahead with that rather than simply waiting a couple of weeks to let that resolve itself so those records could be received. These records are about bills that have been charged over years, and there's nothing that would indicate any urgency other than Ms. Reguli wanting to use these records for some other purpose.
So you're essentially looking at it as a circumvention of the attempt to circumvent the federal court decision-making on the protective order issue.
I would agree with that, Your Honor, and I also think that you have to look at the total picture. I think this would be a much harder case if improper purpose were the only basis for the sanctions. But improper purpose combined with false information contained in those pleadings, and I would suggest that the proof makes it crystal clear that those representations were indeed intentional. One doesn't take a reported case and instead go pull the slip opinion and then mark and highlight things out of context to create a misleading impression if one is not attempting to create a misleading impression. Again, Ms. Reguli actually testified at the hearing when I questioned her that she didn't need to make an assertion that the county had funded a criminal defense for Mr. Cruz. Rather, she could have just said nothing else but that records were requested. To which the court replied, but see, that's the problem. You did say more than that.
But I'm having a couple of problems with all this conceptually. And okay, Ms. Reguli made some misrepresentations about what a court case meant. Happens all the time in briefs we see. I mean, why does what she did go beyond what so many lawyers do in these cases and try and spin a case to their advantage?
Well, with regard to the statement about that particular case, it wasn't just an attempt to spin to her advantage. It was a blatant misstatement of what happened in the case. She expressly said the Sixth Circuit found that holding J.H. in solitary confinement was excessive punishment and violated his constitutional right as a pretrial detainee.
Well, and this is no offense to Ms. Reguli, but how come that isn't just bad lawyering? I mean, I see bad lawyering all the time. I see people say cases mean something, and they don't. I go and read them, and there's nothing there that supports what they said. So should I Rule 11 all these people? I mean, I'm having trouble finding, and of course I wasn't there, I wasn't the judge, I didn't see everything, but just quoting a case and saying it means something that it doesn't really mean, you know, boy, we could sanction 20% of the bar for that.
Well, respectfully, Your Honor, 20% of the bar doesn't choose to make assertions of fact that 20% of the bar admits are not even material to the case for a gratuitous reason and then misstate them. I think that's, and again, that's one of the reasons it's an abuse of discretion standard, because Judge Woodruff sat there and saw Ms. Reguli's testimony, heard about the other things that were going on kind of in the background driving her testimony.
Yeah, and I'd like to ask a little more about what was these other things that were going on. There was a reference made to a campaign brochure that Judge Woodruff received that was sent to every Republican in the county, I think. And was there a misstatement there about this particular case, or was it just about another case? And why, if it's just about another case, why is Judge Woodruff concerned about sanctioning her for that?
It was not about this public records case, Your Honor. It was about the underlying case about which Ms. Reguli made the false statement in her pleading.
Okay.
It was about the case involving this young man who was incarcerated in Williamson County Juvenile at one time.
Okay. And the sanction was because Judge Woodruff considered that to be a false statement that was in this brochure?
I don't believe that the court made a specific finding about the falsity of a statement in that particular brochure, but if I can step back, Your Honor, and explain kind of a little of that context.
Thank you.
You will see in the record an indication that there are two pending proceedings that relate and have been pending for 10 years that relate to that situation. One of them has an entire file that's under seal. One in the federal court has portions of the file that are subject to protective orders. And so one of the arguments the county was making about why it needed to wait for the federal court's ruling rather than let the horse out of the barn before the federal court's ruling was that Ms. Reguli has this history of taking statements from litigation out of context, creating misleading impressions, and using them for an improper purpose, so that if indeed she was allowed to have the records she was requesting before the federal court could rule, there was frankly zero chance, Your Honor, that they wouldn't be used in that manner. And so I think from my perspective and my understanding of the trial court's evaluation, those improper uses in those various campaign ads, social media posts, et cetera, that are in the record were germane to this for that reason.
For the reason that she might do it again.
For the reason that she might do it in a way to circumvent a federal court order, Your Honor.
That's kind of speculative, isn't it?
Your Honor, I would suggest that
know
looking at the record.
I know what you're going to say, that you were sure she was going to do it, but.
And I think the record supports that, respectfully, Your Honor.
Okay, thank you.
I believe I'm out of time. Thank
All
you.
right, thank you, Ms. Carson. Ms. Reguli, you have 2 minutes for rebuttal.
Okay, thank you. First of all, I want to say Williamson County raised hardly any of these issues in the trial court. Williamson County is basically arguing on behalf of the judge and his Rule 11 motion. Remember, Williamson County came into this, they made some basic legal arguments. Juan Cruz did not try to intervene in this case. It was not Williamson County's district court motion, it was Juan Cruz's, and that was part of our argument, that Juan Cruz didn't have standing to object to the public records case. He did not intervene and make himself a
But
party.
if there's a federal court order, you don't have the right to ignore that.
But there was not a federal court order. The motion was pending. We acknowledged that the motion was pending. We acknowledged that. But we said that he didn't have standing to object to those records, and basically Williamson County was making that objection. And they agreed at the end of the March 29th hearing, basically they would comply with that. And then everything else took charge under the sua sponte Rule 11 motion. And the only thing, I don't think Williamson County has standing to argue for the benefit of the judge on that. They never raised any of those issues at the trial court. Now, also, again, this statement is a summary statement, a background about the case, because on assignment in Williamson County, you don't know what judge may have the case. It's just a summary about the connection as to looking further into getting more records. It was not used as an adjudicated fact. It was not used as a legal precedent or as a res judicata in any manner. It was just a summary and showing that tie. And also, then the other, I do want you to take time to look at the other issues, 3 and 5, about the dismissal of the action and the restrictions put on counsel, which should also be vacated, and would just ask for reversal on the trial court ruling. Thank you very much, gentlemen.
All right, thank you, Ms. Reguli and Ms. Carson, for your arguments. We'll take this matter under advisement. That concludes the morning docket. We'll recess.